and craft from the past a credible sounding opinion that purports to be consistent with precedent, purports to be consistent with text, and purports to be consistent with purpose. And you'll have 9 justices, and they'll go 5-4. And they'll each write opinions, each one claiming that they have tapped into the correct reading of the past. And the question is, what is it that's actually causing them to break ties at that point? It can't be because one knows how to read text and the other one doesn't, or one knows how to read cases and the other one doesn't. They're perfectly credible. I mean, we could take case after case very recently. Caperson, the case that was just decided this term, that said if you give a $5 million contribution to a judge and then want to litigate before the judge, your opponent might have some concerns. And therefore that the judge, as a matter of due process and fairness, should step aside in favor of a judge that doesn't have a $3 million debt to you. Now, that's, believe it or not, that was 5-4. Five of the justices, Kennedy swung the right way this time, the 4 liberals and Kennedy. And Kennedy said, no, you can't have a fair hearing under those circumstances. 4 of the judges made a principled argument that said, no, this is not something that we should decide. The Due Process Clause doesn't give us guidance. Neither one of them was wrong. They're not wrong in the sense that one should be made to go stand in the corner because they misread the text or misread the cases. They differ because they took a different vision, I think, of the consequences of the decision. Kennedy thought to himself, the consequence of this decision is forcing somebody to have a lawsuit in front of somebody with a $3 million debt to his opponent. How can you possibly think that would be fair? Roberts and, in a separate opinion, Scalia say the consequence of this opinion is a standardless recusal rule, which is going to be all over the courts, and it's going to be impossible. We're not going to be able to live with it. So they were both focusing on 2 different risks. One was the risk that the system would be roiled. The other one was the risk that there would be an unfair decision in this particular case. And for me, being a good judge or a bad judge is which risk dominates you. If you're dominated constantly by risks to the system, you're going to tolerate huge amounts of injustice. That's what happened to Lilly Ledbetter. That's what would have happened in Caperson. So the question is, what risks? How do you manage risk as a judge? And at the risk of coming back to this, I think you can't manage it without empathy, without stepping into the shoes of the litigants and deciding it as something other than, or understanding, other than an abstract interpretation of the rules. So my answer, Sidney, is that I think in too many cases there are too many ways to lock into the past. In no case do I think you can't lock into the past. The question is, can you lock into the past for just one outcome?
If I might say one word, I just think it's important that when you choose the consequence, that consequence has to be supported by something within the constraints of the process. That is, if it was a complete break from tradition and history and you just chose it, I think that would be very difficult to defend. On the other hand, take Ledbetter. Justice Ginsburg certainly had empathy because she was a lawyer who litigated many of these gender discrimination cases, but she also recognized in her opinion that the interpretation that the court was giving would render Title VII nugatory. That's perfectly within the constraints. She also chose a line of cases which Justice Alito completely ignored, which was the hostile environment cases where you have this kind of cumulative building up. So she, I think, she chose a consequence, but she chose it and she wrote an opinion that satisfied the purposes of the judicial process. And maybe we're saying the same thing, but...
I'm not turning around. Really, I think we have to turn off. You wouldn't say that Roberts didn't write an opinion that satisfied the judicial process, would you? He's just wrong. But it's professionally and technically an acceptable opinion. He read the cases, or Alito, he read the cases the best way he knew how. Nobody was paying him off. He did the best he could within the constraints. And so how is one right and the other one wrong without consideration of the ability to decide which risk is the risk you really care about? And that's a matter of understanding the people who were before you, I think.
I think that consequences is as dangerous a word as empathy, and for somewhat the same reasons, because we're talking about two different kinds of consequences. There's the kind of consequentialism that people object to, which means that you figure out the way you want the world to be, either maintained in its present status quo state or altered in some way, and then work the process until you come up with an opinion that achieves what Ronnie Dworkin calls articulate consistency. But the kinds of consequences that you were speaking of in the Caperson case and in other cases are consequences contemplated by the judges in relation to the system, how that's going to work. And that's quite different from the consequentialism that everybody finds disturbing. One judge is thinking, well, if we do that, we're going to have a parade of cases before us in the next 2 years, and the whole calendar will be occupied by them. And another judge says, well, if we do that, then whole sets of litigants will be discouraged from bringing worthy causes of action. But those are consequences that contemplate future conditions within the legal system. And that's perfectly acceptable, and I think indeed appropriate. And so I'm afraid that you and I agree once again.
I promise I'll use pragmatism. Pragmatism is a less loaded word for that.
Can I just let me give you the example of a case, Sidney, that I think can't be seen as saying the justices were acting in good faith. And I'll do it with a case out of the past so that we don't think we're slandering someone who is currently on the court, since we all have to go talk to people who are currently on the court. Justice Holmes decided a case called Giles versus Harris. And it's about what happens when the state of Alabama, an all-white legislature, took an action that disenfranchised all black people, okay? And that's the claim in the complaint, that Alabama has disenfranchised all black people. And he decides that there are no cases he has to cite here. He just says, well, what would we do if it were true? Let's assume it's true. Then nothing that we would give you would actually help you, because you claim all the white people hate you, okay? And if all the white people hate you, nothing that a court in equity could do could help you. Therefore, we don't have jurisdiction to help you. Case dismissed. Okay, that's Giles versus Harris. It's not in the case books. 1903. It's a disgusting case, okay? I mean, it's an absolutely disgusting case that there is no real argument that what happened violated all sorts of, we have a 15th Amendment, okay? He doesn't say the 15th Amendment doesn't. He just says, well, let's assume you're right? What could we do? It's, as opposed to saying it's an outrage what's happened, we really hope this, but he says, what could we do? Unless we are prepared to supervise the voting in that state by the officers of the court, it seems to us that all the plaintiff could get from equity would be an empty form. Apart from damages to the individual, relief from a great political wrong, if done as alleged by the people of the state and the state itself, must be given by them or by the legislative and political department of the government of the United States. Case dismissed. The next case was the damages case, and they dismissed that one too. Okay, they dismissed that one too. And, the point here is that he didn't appreciate, in my view, what his role ought to have been when a fundamental injustice comes before him. And this is a particular example of the disability of a court that is completely unaware of how insulated it is, has no peers whatsoever, and therefore it's very easy to say, well, that's them. Who cares about them? The Negroes you're talking about, who cares about them? And the point of having, an inclusive democracy is that it's much harder to dismiss the them, and therefore it's much easier to get the imagination, and we can see how this actually plays